Good afternoon. I'm so delighted to see so many of you here for this conversation about national security and the rule of law. My name is Claire Finkelstein, and I am Algernon Biddle Professor of Law and Professor of Philosophy. And a little over a year ago, I started the Center for Ethics and the Rule of Law. The purpose of the center is to protect and enhance rule of law values. In focusing on rule of law values, we have particularly focused on national security issues. The reason for that is probably obvious to most of you, but let me state the obvious nonetheless, which is that the exigencies that we face in national security have threatened rule of law values and posed a challenge to our ability to remain faithful to rule of law values like no other issue in our history has. Of course, national security issues tend to do that, especially in times of emergency. But many of us feel that we are confronting a kind of permanent emergency in national security, and that gives us a potential permanent problem in maintaining rule of law values, in maintaining civil liberties, and indeed in maintaining our commitment to moral norms and open dialogue in our society across many different domains. The discussion that we've been having regarding national security really mirrors the discussion in the larger society, which has been, in one sense, a very wrenching, painful discussion for many Americans and for many across the globe. But on the other hand, it's also been an opportunity to talk about many of our core values and to redefine ourselves as Americans and as a nation. So CERL has been committed to having these conversations and to having them in an interdisciplinary forum. We hold conferences on many issues connected with national security, such as targeted killing, cyber war, the logic of deterrence, and the nature of sovereignty and the changing nature of the executive branch and classification practices. We have been in a discussion today around secret laws and whether or not laws that are essentially non-disseminated and that operate behind closed doors to provide internal legal guidance in the executive branch count as satisfying our need to be governed by laws as a society. We've also been discussing privacy concerns and whether or not of course, the issues connected with the National Security Agency that have been so much in the public eye these days have in any way jeopardized our commitment to rule of law values and our fundamental privacy rights, if indeed we have privacy rights. So that has been some of our discussion today. We've been delighted to be joined by John Chris Inglis, the Deputy Director of the NSA, who I'll be introducing formally shortly. I'd first like to invite Bill Craven to come up and say a few words. Bill and I really started this organization together. It emerged, I had been thinking about starting an organization like CERL for a long time, and Bill and I happened to be seated next to each other at a dinner one night, and we discovered this amazing common set of interests in these questions, but from very different perspectives. Bill was the founder and CEO of Overwatch Systems, which was a software company serving the intelligence segment of the defense industry. Prior to forming Overwatch, Bill had been the CEO of Paravant, which was a public company serving the defense community. And early in his career, he worked as a scientist and analyst for Anderson Electric Company, whose activities included serving as a contractor for the US government. So despite coming from these very different perspectives, I completely an academic philosopher with mainly at that time a theoretical interest in these questions, and Bill very much from the practical side of national security. We found that we both had this commitment to the rule of law and a commitment to bringing rule of law conversations and values into a law school community, which is what CERL has been about. Bill is now the director of our advisory board for CERL, and it's just been a wonderful pleasure working with him. And he and his wife Pamela have also been our first private sponsors. I also want to say that we are virtually entirely supported by general law school funds, and Dean Fitz has been extremely supportive and generous in allowing us to start CERL and really allowing a very free hand in the sorts of things that we organize. When the first conference that we held several years ago was on targeted killing, and when I went to Dean Fitz and said, I want to organize a conference on targeted killing, he said to me, Claire, have you lost your senses? Because I was, of course, a very theoretical philosopher, and here I was proposing this very applied topic. But we have discovered it's worked, and it's remained true to academia's mission to have theoretical conversations and conjoining them with industry. So let me first give a big round of applause to Mike and thank him for all that he's done for CERL. And now ask Bill to come up and say a few words.
Never follow the Dean and Claire because they have made every point that I was going to make. So, but speaking for my wife as well as myself, it really is our privilege to be part of this organization, partnering with the law school to help sponsor CERL. I spent most of my career building systems for the intelligence community and for the warfighters who represent our country so well. And along the way, there were ethical and legal questions that came up that we in our own poor way managed to work our way through. And as I approached my dotage, I really was looking for a way to go back and try to clarify some of the questions and come up with some of the answers in a better forum. When I met Claire, I learned that she had just been out and about at West Point and other locations, meeting with soldiers, meeting with the real grassroots practitioners to understand what some of their problems were. And here's this noted philosopher, legal professor who's out trying to speak to people at that level to understand how they think these things through. And my wife and I were so impressed with that approach and felt that this organization was one that we should try to support, and we're privileged to do that. We have some hopes for CERL. First, that it will be a forum for informed debate, spirited but polite among scholars and practitioners. Number two, our hope is that CERL will use these conferences to produce publications that will guide our policymakers and our legislators in making better decisions about the balance between national security and privacy. So with that, I'll turn it back over. Thank you.
The format of our discussion today will be as follows. I will introduce our keynote speaker, John Chris Inglis, and he will speak for approximately 40 minutes. And then I will introduce our discussant today, who is Steve Aftergood from the Federation of American Scientists. And I will moderate a discussion for about half an hour between Mr. Inglis and Mr. Aftergood. Both of whom are really the two greatest experts on the topics that we'll be discussing today in the country. And then we'll have an audience, a question session. I propose that we do that as follows. We'll be distributing index cards, and if you could write your questions down on an index card if you'd like to, and then we'll collect those cards. If you'd like to read your question yourself, please put your name on the card, and I will invite you to stand at one of the mics that we have here and to ask your question. And if you'd rather that I read your question, you can just leave your name off, okay? And with that, let me introduce our keynote speaker. Chris Inglis is the Deputy Director and Senior Civilian Leader of the National Security Agency. He acts as the agency's Chief Operating Officer, responsible for guiding and directing strategies, operations, and policy. Mr. Inglis began his career at NSA as a computer scientist within the National Computer Security Center. His NSA assignments include service across information assurance policy, time-sensitive operation, and signals intelligence organizations. He was promoted to NSA's Senior Executive Service in 1997 and subsequently served in a variety of senior leadership assignments, culminating in his selection as the Deputy Director. He has served twice away from NSA headquarters, first as a visiting professor of computer science at the U.S. Military Academy, and later as U.S. Special Liaison to the United Kingdom. He is a 1976 graduate of the U.S. Air Force Academy, and he holds advanced degrees in engineering and computer science from Columbia University, Johns Hopkins University, and the George Washington University. He is also a graduate of the Kellogg Business School Executive Development Program, the USAF Air War College, Air Command, and Staff College and Squadron Officers School. His military background included 9 years of active service with the U.S. Air Force and 21 years with the Air National Guard, from which he retired as Brigadier General in 2006. He holds the rating of Command Pilot and has commanded units at the squadron group and Joint Force headquarter levels. We're absolutely delighted to have Mr. Inglis here and very much look forward to your keynote address.
Thanks very much. If anybody hasn't turned their cell phone yet off, just hold up your hand. I'll turn that off for you now. I'm just kidding. Please. Usually in an audience like this, say, who hasn't heard of NSA, so that I might explain that a little bit. If there is someone in the audience who hasn't heard of NSA, hold up your hand. I'll come back and give you a hug. But Bob Schieffer said something really interesting this summer, and I hope to kind of jump right in the middle of this, which is that in the field of national security, in the middle of all of this cauldron of discussion that has taken place across the summer and the fall, it's very seldom that in the course of national security, so many have understood so little about so much. And I would say that kind of kidding aside, I think it's really important that we have discussions like this, and so I'm enormously grateful to Grace, to Bill, the Dean, for establishing this venue. Sometimes this provides the opportunity for the collision of ideas, but never the collision of people, because I think we all have a common objective, which is to figure this out, to sort this out. Because the things that we're trying to bring to bear are those things that are good for our nation or coalition of nations. And that, for one reason, is why I'm here today, and I look forward to what hopefully will be not simply monologues from a pulpit, but rather a dialogue. I do hope to be able to stay well within my time so that Stephen Aftergood, Claire, can have a dialogue with you about various things. I would like in my remarks to essentially make 4 broad points. First and foremost, to kind of start with a foundational kind of appreciation of what's the true nature of the space that we're talking about when you think of NSA and its responsibilities. So often I will appreciate that from an NSA perspective, we start in the middle of our story. We will tell you what we've collected, we'll tell you what we're going to do with that, we will tell you to what purpose we think that we might bring that to bear. But we've not actually explained first principles as to what's the nature of the problem we're trying to solve. Why would that be an appropriate way to proceed? And we find that we're speaking past each other when we actually then explain the means and methods by which we'll achieve something that we haven't actually understood at first principles. So I'll do just a little bit of that, maybe to kind of give the broadest possible appreciation of that. I would then like to talk a little bit about what then drives NSA from a values perspective. I think you'll be pleasantly surprised that there's great commonality there. The discussions that I've heard today would say that we talk about the same things, whether it's from a legal perspective, an operational perspective, or even a technology perspective. We often emphasize different things in that dialogue, and so I'll just kind of lay that on the table. I'm then going to talk a little bit about the nature of what drives my business, how I get up in the morning, what I do, what drives what. So there then might be a basis to explain in greater detail, perhaps in the question and answer session, why do you do X? How do you bound it, control it, aim it? And then finally give a couple of thoughts from my perspective to perhaps stimulate some dialogue but what I think the way forward is for activities like the National Security Agency or for the broader proposition, intelligence in democratic societies. So if that's a fair way to proceed. First slide that I've thrown up, and I'll only use a very few slides right up front in the presentation, is an actual depiction, an actual presentation that if you understood the details underneath this about what it is we're depicting, where it came from, and what it's aimed at, it would be classified, for Stephen's purposes, only classified at the confidential level. But that's another discussion. But what I mean to portray in this is that if you look on this chart, you'll see some number of blue, red, and yellow dots. The blue dots constitute, in a real depiction, this is an actual event that occurred sometime in the last year. The blue dots are the target of a cyber attack that was conducted against the United States on a given day. They actually equate to some financial infrastructure that exists within the United States. And the bigger the blue dot, the more intense the denial of service attack was at that moment in time. The red dots constitute the infrastructure from which the last point of attack was launched. Again, the bigger the red dot, the greater the intensity of the attack that was launched from that standpoint. And the yellow dots constitute the kind of foundational infrastructure around the world that essentially was the host for the various activities that gathered the strength that aimed through the red dots at financial infrastructure within the United States. Here's the great insight inside of this, is that this might show that perhaps Australia was attacking the United States on that day, or that broad swaths of Europe were attacking the United States on that day. Perhaps Indonesia and Southeast Asia was participating in the attack on the United States that day. None of that is true. What is true is that it was a single entity, that's the secret in this, but a single entity that was essentially hurling these Nerf balls at our financial infrastructure that day, and they made use of a global infrastructure that essentially encircles the globe, hijacked that as it were, and then essentially used that to hurl that at the United States of America. Looking at this, you might then immediately come to the conclusion that this global infrastructure is useful not just for good purposes, but for bad. That the global infrastructure is useful not simply if you own it, but if you simply can touch it, if you can find your way to it. And you might conclude that what we then need to do in order to protect ourselves against such a possibility is somehow surveil all of it unilaterally, dominate it, perhaps overtake it, kind of begin to perhaps troll this, traverse this, or perhaps more thoughtfully, this is where I'll ultimately go in the talk, try to understand how a coalition of nations, maybe most nations, would begin to get their arms around this and collaborate to better understand how this infrastructure is created, how it's made more resilient, and how we can understand what takes place on that infrastructure to the point where it can then do the things that we want it to do, because there are good and noble purposes for this infrastructure we know as the internet, as opposed to nefarious purposes that might then hurl themselves at us. I'd like to give you some insight then into the nature of that infrastructure so that I might then tease that out in the other three sections of the talk. So if you go to the next slide, please. Cyberspace, for me, is my workplace. That's where I go to work every day, doing the work that the National Security Agency does. I'm traversing that space for the last 60 years and 70 years plus if you go back to the origins of my mission, essentially finding communications of interest. We call them signals, that's why it's called SIG-INT, but finding communications of interest that have a foreign intelligence nugget inside of them, and then under lawful authority, explicitly granted lawful authority, teasing those secrets out and then providing them to my customers. Which are not simply the United States governments, policymakers, but oftentimes coalitions that I might support. But the true nature of cyberspace is greatly misunderstood by many, not least of which is some people at NSA about, how's this thing really work? And oftentimes when we think of it, we talk about it, it looks just like what's on this chart here. It's this tumble jumble of pipes, wires, devices, people, territory, and they're also horribly converged on one another, perhaps collided upon one another. It's really hard to figure out, how's that darn thing work? What's actually happening inside of that, such that we might, with some deftness, with some agility, maneuver the space, but in so doing, make sure that we hold harmless those things that we might, and hold at risk those things that we must. So if we go to the next slide, I'm then going to tease this out a little bit and talk about some broad characteristics. Some of these characteristics help us, some of these characteristics perhaps confuse us. As in any domain of interest, and think about the maritime domain, the ground domain, the air domain, any domain of interest, there are typically two bookends. There are two boundaries that essentially help define, bracket that domain of interest. One of those is almost always the earth. If it doesn't have the earth as one of those bookends, then we'd have to ask, why do we care about that? And the other is people. Again, we'd say if that's not one of the bookends, then it doesn't serve, or it's not about, or it doesn't have a relationship to people. We'd say, why do we care about that? And so that's no less true for cyberspace than it is for the other domains, and so here they are. These bookends essentially give us a base of experience, and attended to that some bias. Those biases are not necessarily bad, but those biases are pervasive. The bias that we enjoy in this space with respect to geography is that geography might tell us something about the nature of what's happening in this space, who owns what, how things might then occur in this space based upon our experience in geography. The other bookend, people, that also induces a bias. Some of those are a bias induced by policy or by constitution. In the case of cyberspace, there is a bias for the protection of U.S. citizens. The Constitution holds them as being special. That's not to say that other citizens are not special, but the Constitution has a special focus on those things that it guarantees to U.S. citizens. Those biases then kind of are biases we take into this space. I would say, from my perspective at the National Security Agency, the bias about people is a positive affirmative bias. I must respect that. I must somehow effect that, no matter what I'm doing in cyberspace. The bias with respect to geography is the one that's less helpful and sometimes actually confuses or makes it harder to actually do what I must do in cyberspace. Not that I kind of find it something I sweep aside, but it's something that actually brings biases from policymakers or laws into the space that are sometimes not helpful or sometimes counterproductive. Let me give you an example of a geography bias in this space. The American business day is waning as we speak, but it's still healthy and well out in the Midwest or maybe on the West Coast. And so if I were to ask you in the middle of an American business day, how does a communication get from New York to San Francisco? Most folks who've studied their geography, born and raised on the planet Earth, and understand something about the nature of dynamics on the planet Earth, say, I know the answer to that question. It takes a westerly heading. About 3,000 miles, several milliseconds later, it gets from New York to San Francisco, because that's what geography has taught me. Turns out in cyberspace, that's not necessarily the answer, because cyberspace knows somewhere else, not necessarily in these two layers, but somewhere else, it's figured out that at this moment in an American day, those pipes are probably clogged. And it's probably a fool's chase to send that thing west, because it would contend with all manner of other things making their way back and forth. But if you send that communication east, across the Atlantic Ocean, across Europe, across China, across the Pacific, it might go a greater distance, which would take some number of greater milliseconds, but it wouldn't contend with all manner of other things. It might get there more quickly. And in fact, the preponderance of those communications likely goes east rather than west. That confounds people that say, well, I want to bring some order and discipline into this space in terms of how I regulate things. And if I find that the national boundaries or the international boundaries aren't one and the same as the flow of communications, I find that the application of law based upon territory might be insufficient to actually govern the space that acts according to some other principles. I'm just going to very quickly fill out the model for cyberspace just to actually give you some proof positive on that. If you'd hit the next slide, please. I'm going to just tuck three more layers in there. The kind of layer just above geography is trying to show pipes, wires, conduits through which communications flow. When I got into the business 28 years ago, that layer was the only thing I really had to contend with. It was a largely manual affair. That is, the communications that I would chase essentially from one place on the planet to another upon the order of a human being who would manually say, I'm now ready to push this button to send a fax. I'm now ready to dial a telephone to communicate something. I'm now ready to perhaps push what might have been the early days of a point-to-point communication that today looks like email, but there was nothing like email in those days. And so my business in those days was eminently simple. Right? If in those days we had a single monolithic enemy or an adversary, maybe not an enemy, we're all partners on this planet, but a single monolithic adversary, they actually made and constructed and communicated on their nets, and we made and constructed and communicated in our nets, and there the twain shall meet. I could do my foreign intelligence mission in one place without worry that I would run into innocents, especially U.S. persons, that I needed to then protect. Add the other layers in this, though, that kind of middle layer that's got all the ones and zeros on it doesn't really exist, but it's the control layer. It's a virtual layer, and it's the thing that actually we've given responsibility to make the choices about how communications flow, where they're stored, how they actually route themselves around the planet Earth. It's so complex, there's so many devices, the possibilities are so endless, that for practical purposes, we've given over to that layer the control inside of that space. And then right above that are the devices themselves. In my business, what I might actually chase are the devices. I have to somehow attribute those devices to persons, because the device doesn't so much have the status that I must care about. The person has the status, but my business has to somehow figure out what's the status of the person that is attached to a device that might be kind of subject or perhaps prey to the kind of vagaries of the control logic that might be using one or more of those pipes that might or might not be somewhere on the planet Earth. Next slide, please. And here's the problem, is that any one of those individuals who may or may not have kind of a discreetly obvious status has multiple devices, multiple persona, multiple pathways, and that changes millisecond by millisecond. I don't offer this so much by way of excuse, but by way of explanation as to why the space is so darn complicated. It's so hard. I'm often asked, how come you don't build a SIGINT system, an intelligence system, because you're a foreign intelligence entity? Why don't you build a system that never encounters a U.S. person? It's an impossibility. If I'm ever going to do anything in this space to affect my foreign intelligence mission, I necessarily will encounter U.S. people, not as a virtue, but as a consequence, as an inevitable consequence of how the space is actually construed. And what I must then do is to build my system such that it can immediately recognize the status of a U.S. person or not incur upon the privacy of a U.S. person, if that's a great good, and it is, not incur upon the privacy of that U.S. person, even if I don't know moment by moment that that is one. I kind of take the bias that it could be, and I therefore focus on the things I must and not on the things that I shouldn't, and should be then held to account to faithfully execute that moment by moment. I'm going to go to the next slide in a moment. I'd like to go to the second part of the talk, which is then to say, so how then do I think about the business from a principles or a value perspective? As a member of the executive branch, that's where I live, I would say that my view was informed early on by the first lawyer I met at NSA, and there are many, and that's a good thing. The first lawyer I met said, turns out that the way things work in the executive branch is that if you're explicitly granted an authority to do something, then you may do that. If you're not explicitly granted an authority to do something, then you may not. I actually understood that because as an Air Force pilot, that's the way things work. If there's a rule that says you can, then you can. But if it's not written down, then you can, then you can't. My brother was a Navy pilot. They actually have completely the opposite rule set. They have a lot more fun in the Navy. If it's not written down, then you can't, then you can. Which is why when you see posters of Navy pilots, they always have this broad smile. And when you see a poster of an Air Force pilot, they always look like they're pondering something, and they're actually trying to ponder the rule that's going to allow them to take off and get to some other place. That's the way it works in the executive branch, not just at NSA. If it's not written down that I can, I can't. But it's more important, more substantive than that. The oath of office that I took 28 years ago when I went to NSA was to the Constitution. What's noteworthy about that, perhaps self-evident but noteworthy, is that's not an oath to a person. It's not an oath to an institution, NSA. It's an oath to the Constitution, which embodies all of the principles that essentially have formed our government. It's an oath not to the national security portion of the Constitution, but to the entirety of it. And so if there is a provision in there for civil liberties, or if there's a Fourth Amendment that guarantees some measure of kind of unreasonable search and seizure as a guaranteed right for U.S. persons, then I'm honor-bound to meet that obligation as much as the national security obligation that might be written into my name. I mean, they go hand in glove. And so therefore, I'm honor-bound to defend the entirety of that Constitution, not just the part that I might choose. It's not optional, right? It's not for me something that I can say, I have permission to do part of the Constitution, somebody else is going to do the other part of the Constitution. So if you go to the next slide, this then, well, the slide after that, you'll see it looks a lot like the last slide, this slide. If you look at this slide, this is actually, and this slide was written well before the leaks of the summer of 2013. All of these slides actually derive from a presentation that I've been giving in various forums for the better part of 2 years. This slide is how we actually depict the juxtaposition of civil liberties and national security. It's often depicted as a balance, that is, that one trades for the other, that we essentially, in kind of giving more deference to national security, must necessarily take away from the protection of civil liberties, or vice versa. In consequence, that's often the case as we make our choices. But I think in the end, the aspiration, the goal must be something more like this, which is that they're both sufficiently important that they constitute rails under a car, and if they're not both sitting on a solid foundation, if they're not straight and true in consonance with one another, then you're not going to get either. The rail car simply won't move. You cannot, as a matter of course, expect to trade one for the other, and so in that regard, I would say that NSA agrees with its harshest critics. We can't trade national security for civil liberties or vice versa, though at the end of the day, not being able to fully achieve both, we have to figure out how to essentially effect an accommodation of one or the other, and we do, on many occasions, constrain national security in order to hold civil liberties or the defense of civil liberties in the right place. Let me tell you in the third part just a little bit about the nature of my day, how it really works. Kind of having said that I have to have an expressly granted authority to do something, it's actually a bit more complicated than that, because I actually have to have said one thing more. In order to pursue my mission, I first and foremost have to have some priority. I have to have something that at the end of the day tells me what it is I should spend these precious resources on, how I should actually allocate those authorities that are granted to me. In saying that, I kind of would like to hearken back to a European construct that is not richly defined within the U.S. intelligence and security community, but which I think conveys quite nicely. In the European context, when they talk about actually affecting security and civil liberties, they might call it privacy instead, they talk about the concepts of necessity and proportionality. They actually say, and I think the European Commission Human Rights Article 8, that they're not either absolute, that one actually can incur upon the other, but national security, when it incurs upon privacy, must demonstrate, A, that that's necessary, and can only do so with proportion to that necessity. That is, it must demonstrate that it's made both those tests. In the American parlance, in my job, we don't talk in precisely the same terms, but I think we get close to the same place, which is that I start first and foremost with what's the necessity, what's the priority, what's the intelligence need that I'm trying to satisfy, and then second, what authority do I bring to bear, and that authority must be brought to bear in a way that it is least intrusive mode. That is, I apply it in a way that achieves the end purpose and no more, so that I can ensure that I've brought this to bear in a way that respects both of the things that I'm trying to achieve in this space, the defense of national security and civil liberties. At the end of the day, I'll just give you one quick example, but leave it open to questions if you'd want to know more. The kind of much discussed 215 database actually is defined not simply by the order that you would have read in early June, which says to various telecommunications companies, provide telecommunications telephone metadata to the National Security Agency, but it's also better defined by a much longer order, the primary order, that says here are the purposes for which NSA might use it, here are the constraints and controls imposed on NSA's use of it, such that at the same time we get it and then have a capability we might employ, we have some very strict controls as to how I might employ that. Those controls say the following, roughly. That I may only use this database to essentially detect the presence of a foreign-induced terror plot associated with specific terrorist organizations named by the court, to detect that plot as it crosses the seam into the United States. That same data set might be eminently useful to do other things. It might be useful to detect domestic terrorism. It might be useful to detect terrorism that's not been named by the court. It might be useful to detect the proliferation of weapons of mass destruction or organized crime. There's so many other things that some innovative, creative person might say that's useful for, but they're constrained. We've constrained its use and purpose in deference to the protection of civil liberties. It's minimized in its use and purpose so that it might try to effect some accommodation between those two great goods. The last thing I would say is that the authorities typically in this section come with 3 questions that you have to ask in order to understand the authority that you're about to employ. So again, I start with a requirement. I then must find the explicit authority, but that authority typically asks 3 questions. What's the status of the person that I'm about to go find the communications of? Where is that person on the planet Earth? And where is that collection going to take place? Now, until you understand a little bit about the true nature of cyberspace, you might say, well, one of those answers is always going to be the same as the other, right? If the person is of a certain status and he or she is in a certain place, then the collection almost has to always take place coincident or proximate to them. Not necessarily the case. Turns out that the 702 authority, what you might have referred to as PRISM through much of the summer, actually imagines the possibility that the target of my interest is a foreign person, that they are in a foreign place, but that the collection might take place on U.S. infrastructure. If those three things line up that way, then my authority could be exercised under the 702 authority, and I simply exercise it by then kind of responding against the priority with the application of that authority. But there's one thing more, which is that every one of those authorities comes with imposed controls and constraints, either articulated by the executive branch or articulated by the court. And those controls and constraints, from my view, more constrain the application of intelligence than they enable it. That's really my third bit, which is that as I think about intelligence in a democracy, in a free and open democracy, it is necessarily, and I think appropriately, more constrained than it is enabled. If you ask my analyst, are you more constrained or are you more enabled? They say more constrained, and they would say, and that's a good thing, right? That's not something that they would then complain about, though they might kind of from time to time say it would be easier if I had some greater agility, but they would say in deference to the true nature of the Constitution and the kind of the attempt to try to pursue multiple goods, that's an appropriate thing to actually impact our national security with. At the end of the day, if you looked at the multiple authorities I have, they're probably a handful. But if you looked at the controls that come along with them, articulated by various court opinions, by representations of the government to the court, articulated by the executive branch and various policies, executive orders, and the like, they number in the hundreds to thousands that I must, at the same time I'm pursuing my national security mission, determine how do I actually meet all of those things. So coming to conclusion would say, as I look forward after the summer of 2013 and the fall, what are the things that I think might be the lessons for us and how might we proceed and what might be a basis for our discussion today? First and foremost, I would say that if you kind of asked me what has to change in light of the leaks and the discussion we've been having, I don't think that we need a greater commitment or greater fealty to the dual purpose depicted on this slide, which is that we must effect at once national security and the defense of civil liberties. I think that's already appropriately in our mindset kind of a duality, a goal that we have to achieve. Now we can argue as to whether the mechanisms we brought to bear are the right mechanisms, but I think in terms of first principles, in terms of common purpose, we're already there. I do think, however, that we need a new balance with respect to the relationship of secrecy to transparency. I think that what we have discovered during the summer is that in the absence of transparency, kind of in the presence of secrecy, people either misconstrue, misinterpret, or mistrust. And the third perhaps might be the most pernicious of all, mistrust the government's use of authorities that could have multiple purposes, but for the fact that we explained what that purpose might be and the controls imposed on that, and then effected accountability in a sufficiently transparent way that people say, well, that looks not simply unimpeachable, but provable, and you've proven that to me on a repeated basis such that I can then confer, right, the consensus of the people to be governed, not simply using the laws that they're traditionally familiar with, but these things that might otherwise look like they're secret. The second thing I would say is that as we have examined the application of these authorities, these capabilities in a space that is occupied not just by bad people and otherwise innocent U.S. citizens, but citizens of the world, increasingly I think it is useful to look at intelligence not simply as an instrument of national power, but likely as an instrument of international power. There's actually some well-worn practice that would already lead us in that direction. There's what we call inside the intelligence community the Five Eyes community, the United Kingdom, Australia, New Zealand, Canada, the United States, which for the better part of 60 years have, within my business, largely collaborated with one another, using the lowest common denominator of, we will follow, right, our respective laws such that no one of us will ask another to do something we can't ourselves do unilaterally, but we will then aid and abet against the common purpose of things like counterterrorism, counterproliferation. We'll aid and abet one another in trying to find the intelligence necessary to steer policymakers or those who stand in harm's way. In a coalition that has fought its way through Iraq, that now is trying to bring peace, order, stability in Afghanistan, that coalition of upwards of 14 nations, we have again practiced intelligence as an international instrument of power. There are many nations who today collaborate there to share information at the tactical level that might then help the people who go in harm's way to do key leader engagement or perhaps chase insurgents, stay safe, or to focus their time and attention on the right places. And I think that then gives us a body of practice that we can take forward so that the nations who understand how these capabilities are brought to bear in that common space might so much lean towards one another as they might be perhaps tempted at this point to lean away from each other in the face of what looks like provocation. And then kind of just closing, I'd just like to kind of bust two myths, and then I think I stay within my allocated 40 minutes. You might have heard during the course of the summer that NSA and the application of these authorities did two things that might shock the conscience. One, that we violated privacy thousands of times. Another, that we collect wantonly and capriciously tens of millions of communications on European citizens. Let me just address those two things, not so much to say those are the only two things I could address, but to say that I would ask you to consider that against every apparent fact, there might be two interpretations, and there might be a different interpretation than you've heard that genuinely explains what that means, and I therefore argue for a dialogue about these things as opposed to the exchange of sound bites. First, on the kind of allegation that we violated that privacy thousands of times. Actually, if you read that article with some kind of closeness, you would see that the allegations derive from a report that NSA wrote. NSA actually kind of wrote what's called an internal compliance report in the first quarter of 2012, and in that report described what we call 2,776 incidents. Those incidents, each and every one, were things that occurred that we said in a perfect world shouldn't have occurred, but they did, and we therefore have drawn sufficient time and energy of the organization to that to say we need to fix that, we need to make that right. Turns out 2,065 of those, about 75% of the whole, what we call roaming incidents. Now remember what I said earlier, which is that any one of my authorities has to answer three questions. What's the status of the person? Where's the location of the person? Where does the collection take place? If those three things kind of are answered in a particular way, then I apply a given authority. If one of those questions, if the answer to one of those questions changes, then I might find myself using the wrong authority to do something that otherwise is meritorious, and I have to fix that. Roaming is one of the ways that the answers to those questions can change. I'm chasing something, say, on the backside of Yemen. I assume that that thing is there. It turns out that it is, time and time again. All of a sudden it winds up not being in Yemen anymore. God forbid they didn't check with me before they moved. And I find that they've roamed to a different place and I'm using the wrong authority. That's a roaming event. And catching that at the first instance is actually, in my view, a feature. It's not a violation of privacy. It's an incident that says we have to actually make a correction in the system. And catching that quickly and then bringing that to the right place is actually something that I would say, I wouldn't say that I'm so proud of it because I should be proud of other things, but I would say that it's something that should be declared as a feature in the system. It's meritorious. Let's talk about the remaining 711, the other 25%. The remaining 711, as described in that report, cover a broad array of things. They were all mistakes, none willful. I think the report goes so far as to say that. And what they constitute are mostly what we call fat finger mistakes, as opposed to kind of implementing a selector, a telephone number, an email address that we would then put on a collection device using the number 3, we put the number 2, or we put the number 5, but it's wrong. Right? Most cases when that happens, the intent was to target something foreign, right? So if we're about to violate somebody's privacy, it's a foreign person. Not that that's not important to me. It is so important that we get it right that we'd actually stop that action, back up, and get it right. So we also protect the privacy of innocent foreign people. But in most cases, because the number doesn't exist, it returns nothing. And they're generally caught because we have checks in the system that essentially try to, at the discrete level, check everything twice. And so if it's kind of forming the selector, or if it's essentially querying the database or disseminating something, they constitute about 711 errors. Here's a statistic that wasn't in the report because we didn't think that this report would actually have the kind of audience that it does. We didn't think it was going to hit the bestseller list. But if you attributed those 711 errors against all the analysts that work and live at the National Security Agency, you'd find the average analyst at NSA makes a mistake about once every 10 years. I know I can see the shock and dismay. That's far too much. I'm not being facetious. I think that one mistake is too many. We need to have an aspiration of fixing all of them. But I would ask you to take that in context. Turns out that the accuracy rate at NSA is 99.99984 for the actions that are described in that report. And the report actually was a base report that we use to essentially derive information that we then report outside of ourselves, so we're not the fox guarding the hen house. That's another alternative explanation of that report. The tens of millions of communications collected against Europe, you would have seen an open testimony that General Alexander, my boss, before the kind of House Permanent Select Committee on Intelligence, gave, I think, an appropriate description of that, happens to be true, which is that those collections, the 70.3 million collections, say, against France, were not against France. They were actually against another entity. They were in Afghanistan, Somalia, places like Mali, where coalitions like NATO have troops in harm's way. And they were actually collections made by NATO organizations provided to the United States as the aggregator of that. We essentially create the infrastructure and then can present back to the coalition of nations the kind of collective result. The same allegation was made earlier this week in Norway. There was a report out in a Norwegian paper that says the United States collected tens of millions of communications against Norway. Here's the chart to prove it. It's got Norway in the upper left-hand corner. The Norwegian SIGINT service, their equivalent of me, immediately came out and said, nonsense. Norway collected those. We provided those to the NATO allies. The United States actually organizes all of that, and that's just their internal kind of device to manage that. That is not to say, having explained those two things, that I don't do foreign intelligence. I do foreign intelligence, but I do it against the requirements that are given to me by the executive branch. I do that in the spirit of necessity and proportionality. And I do that in a way that affects not just national purposes, but often international purposes. Those are not things I then ask you to hold as being unassailably true, but it's a perspective that I would ask you to consider and then engage me in dialogue if you want to challenge that or tug or pull at that. Because I think at the end of the day, what we really need is a dialogue about these things. And if the nation chooses to change, right, its allocation of authorities or its delegation of authorities to something like NSA, our obligation is to accept that, right, to embrace that, and to move on, and to execute that in full deference to the Constitution, which says that we will affect national security and the defense of civil liberties in a way that the framers would be proud. Having said all of that, those are my prepared remarks. I would simply close where I began, which is to give an enormous thank you to this venue for an opportunity to engage in a dialogue of this sort. I would say that this would not have been impossible a year ago, but I'm not sure that we would have been as interested as having this dialogue a year ago. And so if anything, in the fall of 2013 and forward, I look forward to more dialogues of this sort, because I think this really is our kind of way forward, right, to kind of have tough discussions, a conflict possibly of ideas, but likely not of principles, so that we can reconcile those in the mechanisms that then give us the practice and the practical mechanisms that would allow us to do this as we must for our respective peoples. So Claire, over to you for the next section.
It was extremely interesting, and we've also had a very interesting day dialoguing with you. Your willingness to speak with students as well today was very much appreciated, and we're so glad to be able to have this open dialogue with you around topics that are controversial, to say the least. I would now like to introduce our discussant, who is Steve Aftergood. Steve Aftergood is a senior research analyst at the Federation of American Scientists. He directs the FAS project on government secrecy, which works to reduce the scope of government secrecy and to promote public access to government information. His blog, Secrecy News, reports on current developments in secrecy policy and provides direct public access to official records of policy value that have been suppressed, withdrawn, or that are simply hard to find. In 1997, Mr. Aftergood was the plaintiff in a Freedom of Information Act lawsuit against the Central Intelligence Agency, which led to the declassification and publication of the total intelligence budget for the first time in 50 years. In 2006, he won a FOIA lawsuit against the National Reconnaissance Office for release of unclassified budget records. I should also mention that he is an electrical engineer by training, holding a degree from UCLA, and his work on challenging government secrecy has been recognized by the Electronic Frontier Foundation with a Pioneer Award in 2010, the James Madison Award from the American Library Association in 2006, the Public Access to Government Information Award from the American Association of Law Libraries, and the Hugh Hefner First Amendment Award from the Playboy Foundation. Thank you so much for joining us. Well, I have a few questions that I'd like to ask both of you. he's considered a hero for putting this information into public view, and for other people, he's considered a criminal not only technically, but also morally so. So let me start with you, Steve, and was Snowden just morally justified in revealing the information?
I'm not in the position of issuing moral justifications for anybody. I would say that I wanted to know the information he disclosed, and I think it facilitated and enabled a debate about fundamental issues involving intelligence collection that needed to take place. I think there are reasons to wish that the debate could have taken place without the unauthorized disclosures of some sensitive classified information. That did not happen. I think one of the lessons of this episode for the future is whether it is possible to anticipate similar cases by preemptively disclosing essential facts about government programs in a way that will enable the necessary public debate. The problem here, the problem with for example, the bulk collection of telephone metadata by NSA was not simply that it was secret, but that we were told it was not happening. In other words, there wasn't simply secrecy happening, there was deception of the public. And that's always problematic, and it has created a trust deficit, and it has created a kind of skepticism towards NSA and towards the intelligence community generally that will take some work to repair.
Do you agree that the NSA was deceptive and that Snowden's revelations demonstrated that?
I don't. I would say that there was ambiguity in the framing of the questions and in the framing of the answers, and that's not helpful if what you're trying to understand is the kind of the precision of what's actually taking place. And I therefore think that clarity in the questions and equal, if not greater clarity in the answers is what's required. As to the question of morality or kind of a moral purpose on Mr. Snowden's part, I'd say that in my world, morality requires ends to be reconciled to means, and I don't see that in this case that the ends justified the means. It's a fairly coarse, blunt instrument that he employed. There were many other ways to essentially exercise his concerns if he had chosen to do so.
Let me follow that up by asking you whether or not you believe that there are ever circumstances in which it would be justifiable for somebody to leak classified information.
If you have exhausted all reasonable means, I think so, that at some point you kind of can get to a place where that's morally justified. It's hard for me to imagine understanding the means that are available that you'll actually get to that place. But
Can you give us a hypothetical? Just make one up in which it might be.
You're kind of in a tactical situation where you're kind of told to do something and you don't believe that it's been legally justified. You kind of ask the question of the kind of authority who's just told you to do that. You get an answer that doesn't square, or you're just told to kind of shut up and do it. At that point, you may then have to make the hard call of your fundamental obligation is to the defense of the Constitution, not fealty to a person or organization. We're not an instrument of organizational power. We're not an instrument of personal power. We're an instrument of national power. So at that point, you may get to the place where you say, I have a greater obligation, which is to kind of make a hard call. Those are so few and far between, it's hard to then, in my experience, kind of come to grips with where I've seen that take place. I'll tell you that in this particular situation, there were so many other instruments that might have been used to essentially raise a hand, ask a question, not getting the satisfactory answer to that question, to raise a concern, to kind of lodge with an IG either inside or outside, to exercise whistleblower provision. I mean, there were so many of those. None of those were used, and so it's really hard for me to then take that situation and say, can I get to the place where I can justify the action taken against the ends that were in mind?
And just one final follow-up question for you, and then I'll turn back to Steve. Do you think that there's been any benefit, nevertheless, to the country from the conversation that the leaks have generated? We're all talking about privacy rights and engaged in this conversation partly as a result of those actions.
So General Marty Dempsey, who I love, he's the chairman of the Joint Chiefs of Staff, he's got a quote which I'll kind of plagiarize and therefore not get entirely right. says, never miss the opportunity to use a crisis to effect a good transformation, a great transformation. And so I think that's where we are. Given where we are, this dialogue can be incredibly helpful, right? Not simply to restore trust in a system or a system of practices, but to go forward such that we strengthen the bonds of trust between the society that grants their authorities through the electorate to institutions like myself. So that's what I'm looking forward to.
Let's
Well,
you wanna respond to that.
I'll answer with a quote from Senator Wyden this week. He said, using a sports analogy, that it's understandable that a team would keep its playbook secret, but it cannot keep the rule book secret. And what happened with the bulk collection and other aspects of NSA programs is the rule book is secret or too secret. And that has, that has created a problem. Was Edward Snowden supposed to go to the Senate Intelligence Committee? The Senate Intelligence Committee is fully supportive and indeed fully complicit in the program that he was concerned about and that a significant subset of Americans are concerned about. So that would not have been a fruitful place to go. When Senator Leahy and colleagues asked the Inspector General of the intelligence community, Mr. McCullough, to please review the implementation of the 215 program, he said, we just don't have the resources to do it. So again, that doesn't seem like a very promising place to go. What's interesting to me in terms of oversight is that the divide in Congress over the bulk collection programs is not between Republicans and Democrats. It doesn't line up by political party. Rather, the bifurcation is between the intelligence committees, both Republicans and Democrats who are supportive of NSA programs, and the judiciary committees, Senator Leahy, Congressman Sensenbrenner, both Democrats and Republicans who have introduced legislation to end bulk collection. And that's a source of puzzlement, and it raises questions about the role and functioning of the Senate Intelligence Committee as an oversight body.
So I'd go further in your allegation of a conspiracy to say that the conspiracy implicates the Foreign Intelligence Surveillance Court as well. So what you have is the trifecta. Yeah. You have the executive branch, you have the legislative branch, you have the judicial branch conspiring, right, to essentially effect a regime that is fairly detailed, fairly well detailed in terms of the orders of the court, the controls that are imposed inside of that, the interpretation of the 215 statute, which I earlier in our discussion said that Madison would call that government. The question isn't whether this is appropriate or not, but who gets to determine that it's appropriate? Do you have to, in something of this sort, get the thumbprint of 315 million Americans to say that we can proceed, or can they rely upon the actions and judgments of some surrogates who stand in the shoes and make those choices? I would say that it's not beyond comprehension to me that the kind of intelligence committees, which are charged to have a greater understanding of how these things actually work, would have a greater confidence and therefore a greater level of support for these things. Not so much because they're sufficiently familiar that they become complacent, but they're sufficiently familiar that they have dogged it and kind of tested and probed and poked to the point that they are comfortable to say, we think that this is the right and proper thing to do.
So let me ask a question now about surveillance practices and come now more to the heart of the NSA's recently revealed practices. So there are two circumstances in which the NSA can discover and search for information with regard to Americans. One has to do with what we've been talking about, the collection of bulk data, also known as metadata, which for those of you who may not be clear what that is just the, as you put it to us earlier today, the to and the from on the envelope. Phone records as well as the who has been emailing whom without the content of those emails being revealed. In fact, the ACLU has filed a suit challenging the NSA's collection of metadata, and arguments on that suit were heard in the Southern District of New York just today. So we'll be hearing a lot about that. The other circumstance is where an American is involved in a communication with a foreign national where the NSA has reason to believe that the foreigner poses a threat to national security. There is then incidental collection of data from the American involved in the conversation, the phone conversation or the email conversation, and that has been judged to be permissible. So the question that I'd like to start with you, Steve, and ask you is these are these exceptions to the privacy rights of Americans do cut into those rights. One with regard to this idea of metadata, which I gather the Europeans reject the distinction between metadata and contentful data. So why don't we start with that topic and then we'll move on to the other. Do you think that the Europeans are right to reject that data, and do you think it's correct to oppose the NSA's right to collect such data?
I would answer this way. I mean, I care about privacy, but privacy is not the only thing I care about. I care about security, I care about protection of the Constitution, I care about counterterrorism. In several of the FISA court decisions that have been declassified recently, the judges were sort of scratching their heads saying, you know, NSA is over collecting, they're not complying with previous orders, the law is not clear on what to do, and they're sort of scratching their head. And in the end, they say that we've been told that these programs are vital to national security. They are essential. They are productive. They're the best we've got. And they said that based on that finding of necessity, they're going to give the go-ahead and say go ahead. But it turns out that that assumption is contested. In an amicus brief filed by Senator Wyden and Senator Udall this week, they said that as members of the Senate Intelligence Committee overseeing these programs, we have seen no evidence that the bulk collection of Americans' phone records has provided any intelligence of value that could not have been gathered through less intrusive means. So, you know, if I could stop a terrorist attack by inviting Mr. Inglis into my house, I'd say of course. But, you know, if it's not going to make a difference, I would still invite him. But the calculation is different. And so we have a basic factual disagreement here about whether these programs are vital, essential, and the best we have, or whether they are sort of, you know, so-so and could easily be substituted by less intrusive programs.
Steve, you've conceded something in what you just said that surprises me, namely that it's, if it makes a really big difference to national security, then of course you're in favor of it. So that suggests a kind of consequentialist approach or utilitarian approach to how we think about invasions of privacy. But if we do have a right to privacy, we think of that as a right that shouldn't be traded away for the sake of exigency.
Well, I would say it's a right that should not be taken away. I reserve the right to trade it away if I see fit. You know, it's.
But this would be the government trading it away on
well,
our
that's
behalf.
You know,
So
if it's compulsory and without an opportunity for choice, even vicariously through my representatives, then that's not legitimate. But you know, but I can, you know, I'm not an absolutist that would insist that no infringement on privacy is ever tolerable. I think that would be absurd and that would be immoral.
But you do want to allow that more invasive surveillance practices are justifiable depending on the level of threat that we are dealing with and the benefit that we get from those invasions.
In real life, it's a factor that has to be considered, yes.
So could I add?
Yeah, I was going to ask you to comment.
Yeah, so I don't think so much that Senator Wyden and Senator Udall have observed a discrepancy in facts, but rather a discrepancy in valuation. I think their opinions are honestly held, extraordinarily noble intent. There are 13 other members on that same committee who have juxtaposed, you know, they've got diametrically a different opinion, such that the committee has uniformly held that they do see the value, and not based on a broad assertion by the government unsupported, but essentially upon the declaration of what the facts are underneath that. Again, I think that Senator Wyden and Senator Udall have been extremely principled and consistent, right, in their advocacy for the position, and it is a necessary dialogue that we have to have. Similarly, with the court, the government has not simply broadly asserted that you must approve this, but has provided the broad facts underneath that, which would then justify that to the court's satisfaction. The 215 program essentially derives from what the 911 Commission observed as the failure of the intelligence community, the foreign intelligence community in particular, to connect the dots. That if we were aware of a foreign-based terrorist plot, that we had no means by which we could detect the kind of crossing of the seam of that terrorist plot into the United States. In 12 years, we have not devised another alternative method to essentially test the proposition that a plot we have reasonable suspicion to believe, has a U.S. nexus. We've not found another way to test that. This one essentially allows us to cover that seam. It is more an insurance policy than it is then a daily instrument of kind of exhaustive exposition about what the nature of those plots are.
Now, Chris,
And like an insurance policy, you don't throw that away if you're not exercising it every day. There's at least one but-for case, which we can say with some confidence, but for the existence of the 215 program, there is a plot that we would not have caught, that the FBI would not have caught. And I wouldn't say that then one justifies the whole, but that is something that we have to think about as a nation of what risk do we want to take? If we're willing to take that risk because we think that the candle's not worth the flame, that's an appropriate policy call. But I think there is a basis for the program that's based on real experience.
Now, when you say the 215 program, you mean, of course, Section 215 of
I
the
do.
Patriot Act. But the Patriot Act, and that section in particular, doesn't make any mention of metadata collection or bulk collection. So what do you take to be the legal basis for the NSA's collection of this data?
Yeah, so as an engineer by training and a pilot by avocation, I'm not at at this moment able to give you the kind of full details, but there actually is a quite kind of richly written paper that kind of talks about what that basis is, and roughly the government has declared and the court has accepted that the relevance is that in the absence of the haystack, we can't test the proposition that there's a foreign terrorist plot that crosses the seam from a foreign domain to a domestic domain. And so the collection of those records is relevant to the determination, to the detection of that plot.
So this
There's
is
also under
metadata,
Smith
where you
versus-
don't need a foreign national involved. So with regard to metadata, you can collect it directly from Americans.
But the order of the court says that there must be a reasonable, articulable suspicion, right, that the seed selector that you're going to essentially insert into this database, and again, it's just numbers. There are no names, there's no locational data in this database, no content. That the number that you're going to put into this database, you have to have reasonable, articulable suspicion that you can attribute that to a named terrorist organization prescribed by the court. And what you're looking for is a connection between that terrorist organization and some domestic entity. If determined, what NSA then does is to essentially tip the FBI. I do not pursue that because I don't have domestic authorities. In the absence of a warrant, I can't target the communications of the content of the communications of a U.S. person.
So let me ask you, if the exigencies were great enough, would it ever be permissible to collect data, contentful data, directly from Americans who are not in conversation with a foreign national?
No, the law is clear on that I need a probable cause warrant. One benefit of the 2008 update to the FISA Amendment Act was that it tightened the provision that says no matter where you are on the planet Earth, if you have U.S. person status, that's more than a United States citizen. If you're kind of a permanent resident, if you've applied for permanent residence, if you're an incorporated entity in the United States, I cannot target the content of your communications absent a probable cause-based warrant from the court.
Steve, let me ask you to comment on that as well, in particular on the rule that says that if you're in conversation with a foreign national who poses a national security risk, that it becomes permissible to collect incidental data from Americans, and that data would not be metadata. That data can be contentful data. Can you make some comments about that?
Well, I mean, on that specifically, I think it's not simply permissible, it's practically unavoidable. The question is, how is the U.S. person data handled? And I guess NSA says it's minimized, it's taken out of circulation. But I would make a larger point about, you know, what the law says and relying on the law. The Foreign Intelligence Surveillance Act said that it was to be the exclusive means for conducting intelligence surveillance. But we know that under the Bush administration, what became known as the terrorist surveillance program was conducted outside of what was supposed to be the exclusive means. How is that possible? Well, the Bush administration said it was possible because the NSA is a combat support agency. The president is the commander-in-chief of the armed forces. The president, under his Article 2 authority, said, go do this. And, you know, so it's not simply a question of what does the law say. In fact, that question arose in my mind when you said, if the American people decide not to do bulk collection, that's, you know, we won't do that. But what if the American people decide that, but the president decides we will do it? And I, the president, order you, NSA director and deputy director, go do this. That's a real question, it seems to me. And to sharpen it even further, what do you do if Richard Nixon is your president? Nixon famously directed the CIA to investigate the anti-war movement on the suspicion, essentially groundless as far as I know, that it might have been infiltrated by foreign communists. What if the next Richard Nixon says, we think protesters at the University of Pennsylvania are connected with Islamic extremists, go check it out. What do you do? What if the NSA director is J. Edgar Hoover? You know, what do you do? These are questions that as a matter of public policy have to be thought through and appropriate protections installed.
Yeah, we're quite fortunate that based upon those experiences from the 1970s that we have codified in law, the Foreign Intelligence Surveillance Act of 1978, and then its update in 2008, we've codified in law precisely what is permissible and what is not, and have essentially effected three branches of government's participation in the interpretation and the application of that. If I might, to the 702 question, which is it permissible to incidentally collect the content of an American, a U.S. person's communications? And I apologize that we're focused on U.S. citizens. I think that there's an equally rich discussion to be had about how do you protect and hold harmless, innocent foreign citizens. But for the moment, we'll talk under the kind of rubric of the Constitution. Would say that as a practical matter, every conversation has at least two communicants. Each thinks it's their communication. So, you know, the kind of party that I might be interested in and authorized to target is having a communication with somebody else that is not necessarily of interest to me. They're not necessarily implicated in the issue, the kind of activity that I'm authorized to chase. But that's all we're talking about when we talk about incidental collection. We're not talking about somehow sweeping up another communication that, you know, has no relationship whatsoever to the one that I'm after. The court recognizes that in its declaration of what the rules are. The executive branch recognizes that in the articulation of those rules and says that when you find a communication that is of material interest to you, you had the priority, you had the authority, it turns out that at the end of the day it's what you are after, you must have an additional burden levied upon you, which we faithfully execute, which is to minimize those things in that conversation, that communication, that you don't have a basis to hold. That would be U.S. person identities, that would be non-FI, foreign intelligence related material. And so that burden is never removed. It's not that, hey, now that I've collected it, I'm safe and I can then do what I will. You actually have a burden that continues all the way to the moment that that is destroyed, whether that's even 25 years later.
Well, so that leads to my next question, which is once you've collected all this incidental data, which you've suggested one ought not to keep forever, it puts the NSA and in a sense the American people in a difficult position, because you could use this data for all sorts of things. And what if you could use this data to prevent serious crimes? Not only might that be a good idea, but you might have a moral obligation to do so. You might have a legal obligation to do so.
I'm an Air Force pilot, remember? So I'm only authorized to do that which I'm explicitly authorized to do. However tempting it might be to reach into those data sets and to use them for other purposes, I am proscribed from doing that. I
So
can't
the logic of
divine my own
necessity and
authorities.
proportionality that in fact you've both agreed to, this is common between you, and indeed you've also said, Steve, that the collection of incidental data is unavoidable. One could take a tougher line on it and say, look, there's American involved in the conversation. This is content-based data. You can't collect it, right?
They don't trump the law. They follow inside of the authority. And so once I've determined the authority, I then need to apply it in a way that has effective necessity and proportionality. I can't actually declare necessity and proportionality allows me to define and bring to bear a new authority.
Okay, but once we have this data, are we really going to get rid of it, and aren't we going to be morally pressured and potentially legally pressured to make use of it?
I mean, I think the question stands. I would add that one of the sources of anxiety about these programs is that they don't have a clear limiting principle, at least one that's clear to me. You can collect telephone metadata records. Why can't you collect bank credit card records or health records in bulk, saying we're not going to look at it, but maybe someday we're going to need it and we'll have it there. The logic of the program leads to places I think we may not want to go.
I think it could, and so that's why we make these choices, discreetly, one by one. You could, in fact, say that in addition to the metadata that we're collecting in the metadata, the 215 program, that I would like to have geolocation data associated with these numbers, not necessarily subscriber data, the identity information. There's a body of work that says that that could be legally permissible, but the government has chosen not to do that, and has even gone so far as to say not only will it not make an application to the court to do that, but it will actually make an application first to the Congress to say that the government's going to choose to pursue that interpretation.
So I want to cover one final area in not too great depth so we can let in audience comments and questions. And I hope you're filling out your index cards, and please pass them to the end of the aisles, and we'll be collecting them. And the final area that I want to cover is the Fourth Amendment and the exclusionary rule. The Supreme Court has recently said that it is a violation of the Fourth Amendment for to collect, to put a GPS tracking device on an automobile and collect data about the whereabouts of a criminal suspect. However, individuals who are not criminal suspects do not have privacy rights in the same way, because it all develops under the Fourth Amendment and the law of illegal searches and seizures. So many people have complained this is ironic that criminal suspects have greater privacy rights than non-criminal suspects. Should the analysis that the Supreme Court has recently engaged in be extended beyond the Fourth Amendment area, or is it appropriate that criminal suspects have greater privacy rights in this regard, given the fact that the stakes may be higher for them, given that they face a potential loss of liberty? Steve, let me ask you to comment on that first.
I am not an attorney, although I was a pro se Freedom of Information Act litigant, which is not quite the same thing. So I think I would refrain from answering the question directly. What I would say is that the constitutional analysis that is presented in the declassified opinions of the Foreign Intelligence Surveillance Court show telltale signs of representing only the briefs of the government. They do not present the full richness and diversity of opinion on these issues, and I think they demonstrate the need for a more adversarial approach in the courts.
Comment on the Fourth Amendment issue?
With respect to that particular case, given that bears on the application of those authorities to domestic criminal matters, it's well beyond my remit to do that. To the point that Stephen made about the possible value of an adversary at the court who might represent, particularly on interpretations of novel interpretations of the law, an additional perspective, I think there's merit to that proposition. It's beyond my remit to say yes or no to that, but I think that that's a fairly put
and of course, the ACLU's current suit is an attempt to bring this outside of the criminal arena, and it's based on Fourth Amendment as well as First Amendment objections to the collection of metadata. Well, we have first, as we begin our questions from the audience, the National Lawyers Guild has asked to make a statement that I'll ask you both to comment on. We have student representatives here from the National Lawyers Guild who have been tracking this issue and very focused on the issue of data collection and privacy rights. Jack Regenbogen is a second-year law school here at Penn Law, and he's going to speak today as a representative of the National Lawyers Guild and read a statement on behalf of the NLG. Just to give a little bit of background, the NLG was founded in 1937 as the first racially integrated bar association. The NLG has focused on major political issues, especially related to civil rights and constitutional liberties. The NLG unites lawyers, law students, and others in the legal system to defend the proposition that human rights should be regarded as more sacred than economic rights. So, Jack, why don't you read the statement?
We want to start by just thanking you, Mr. Inglis, and everyone for taking the time to be here today. We really appreciate it. As each week ushers forth a new NSA scandal, each one more egregious than the last, we cannot help but recall the wise words of a local favorite, Benjamin Franklin, who once said that those who would trade liberty for security deserve neither. One can only wonder what Franklin would think if he were here today to witness this unprecedented erosion of privacy that has occurred under the NSA security regime. The scope of the NSA spying program is truly terrifying, and the NSA has resisted transparency by engaging in a persistent pattern of deception. As recently as August, the NSA's legal counsel dismissed claims that the agency was spying on public figures. Now, however, we know that the NSA was operating such a surveillance program, stirring international outrage that's ongoing. More alarmingly, the NSA was misleading the public by claiming that a valid court had authorized every invasion of personal privacy. By your agency's own admissions, however, there have been several blatant abuses of power, including analysts using their access to privileged information to spy on ex-girlfriends. Beyond these bad apples, though, the deliberate lack of transparency within the FISA court framework structurally produces a system that is ripe for abuse. Earlier this week, the inherent unaccountability of the FISA courts came to light as a declassified opinion by FISA Judge John Bates voiced concerns that the NSA could not function within the rule of law. The truth about exactly what data the NSA is collecting is still ambiguous. Former NSA analysts have alleged that the specific word-for-word content of all electronic communications are being collected on a scope far beyond mere metadata. These claims are substantiated by the quiet construction of your agency's 100,000 square foot data center located in Bluffdale, Utah, which former NSA official William Benny pointed out could collect over 100 years' worth of communications. These facts suggest that the content of every single communication is being seized and stored by the NSA. In light of these revelations, we demand that the NSA cease all illegal spying programs. More specifically, it must halt the blanket telephone and internet surveillance instituted under Section 215 of the USA Patriot Act and the FISA Amendments Act. As a critical precursor for restoring the public's trust, we also strongly urge the NSA to transition from a reliance on the FISA court system to a more transparent judicial process. Further, the NSA should publish all secret legal decisions and details on all surveillance programs, so whistleblowers like Edward Snowden don't have to risk their livelihoods to keep the public informed. In short, we do not feel the blanket justification of an endless war on terror justifies the unprecedented expansion of surveillance powers. The stakes are high, as our personal privacy protections are under constant assault. The leaders who implemented these programs must be held accountable. Until the surveillance state ends, the NSA's spying programs will continue to be a major threat to our national security and welfare. The time to begin restoring our constitutional liberties is long overdue. How do you plan to address these serious constitutional grievances?
Thank you, and I'd like to really thank the students and the NLG in particular for being part of our conversation today. I think it's earlier today, Chris met with several students from the NLG, and I think this has really enriched our discussion, and I really want to thank you for being willing to have that discussion. So let me turn it over to you to respond, and then Steve, I'll ask you to do the same.
First and foremost, I would say to Jack and all of his colleagues, I appreciate the vigor and purpose with which you pursue your concerns. I appreciate the courage to stand up in an audience and to actually kind of then give voice to those. I disagree with most of what you've said, but in a free and open society, I think that that's your right and my right to kind of disagree. You have alleged that what you have just cited is a kind of a set of facts. I strongly repudiate that, strongly. Let me just go down and talk about some of these things, not so much to kind of challenge your right to say what you said, but to say that my rendition of the facts would be completely different. First, I would agree with you. Franklin's right. We should not trade liberty for security. We agree with that. We need to find a way to do both. We cannot give one away for the other. You might say you shouldn't give liberty away for security, and I would say vice versa, but we're agreeing on that. We need to find the right proposition, and we need to use all the instruments of government to do that. Add the fourth estate in as a useful kind of light to shine on this, and I think that you've got everybody in the room. You say the scope is terrifying. That's a pejorative statement. I would say that the scope is limited to the point where it is necessary and proportional, but we can have, I think, a reasonable disagreement on that. You say that NSA legal counsel dismissed that it was spying on public figures. I gave you my card earlier to ask you to send me that quote, and kind of I'll help understand, or you can help me understand where perhaps we said something.
I was referring to an interview with legal staff Joel Brenner with PBS NewsHour.
He's not my legal staff.
It was NSA legal counsel.
He's not. Joel Brenner is a one-time member of the intelligence community, a good person, but he does not represent NSA. He's not an authoritative committing official for NSA. He's a member of the private sector at this point in time. You did cite that there were 12 willful abuses across the last 10 years. That's true, right? 12 individuals out of probably something upwards of 100,000 who had the chance to essentially misuse the SIGINT system did. 7 of them were NSA employees. The other 5 were members of another organization who serve inside NSA spaces. But I'll take responsibility for all 12. Every one of those was caught, dealt with appropriately. 7 of those were referred to the Department of Justice for prosecution. I'll leave it to the Department of Justice to say what they did about that. There are human beings working at NSA. The majority of those were attempts by those NSA and other personnel to focus the SIGINT system on foreign persons, right? You kind of called it love-int. We don't call it that. Some of those were girlfriends, but they had the right to make sure that the NSA system wasn't misused against them as much as any other person on the planet. And we found those, dealt with those, corrected those. Here's a statistic that's out there, but nobody chooses to cite this. During that same period of time, 20 NSA personnel lost their lives in harm's way. So it's 3 times more likely that you'll die for your country if you work for NSA than you will abuse the system. And I would ask any organization that's the size, scope, scale of NSA to comport with that statistic of those very, very few but intolerable abuses. We dealt with those. You say we can't function without the rule of law. I absolutely agree. I absolutely agree on that. And so that's why I enjoy being in this dialogue with you, and I mean that from my heart. You kind of cite NSA Utah as proof positive that we're collecting word-for-word content on all Americans. I repudiate that absolutely, both in terms of the collection of the content word-for-word of all American communications. Despite what 1 or 2 people might say, it's simply not true. And if it were to be in one scintilla true, I should be held to account. Ultimately, you said I should be held accountable. I should. NSA Utah is not built for that purpose anyway. We should cease all illegal collection. I agree, but there's none going on in my view, and so I think that we've met that obligation. Urge transition to a transparent judicial process. The process we have is one that has been worked iteratively across tens of years, not simply the last few years. And so what we've got in terms of how the governance system works across the executive, judicial, the legislative branch is the iterative result of what we've worked over all that period of time. There will be further adjustments to that. Your advice and counsel, I think, can be useful to that, and so I think that that's helpful. And to the point about, kind of allowing the next Snowden to do what he does without taking some personal risk, I would point you to the 99,999 or so who didn't do what Snowden did, who essentially kind of went about their business on a daily basis, full of the principles that we hold these people accountable for, not simply mindlessly executing their jobs. But there are so many, right, who, unlike Snowden, exercised that principle, that conscience within the system, as opposed to taking it an extraordinary means, to their time and attention to operate outside the system. And so, in sum, I thank you for your comments. They influence me. It's something that I need to speak to, but that's how I feel about what you've said, and I'm happy to be in a further discussion with you.
Steve, can you respond? And to what extent do you agree with the statement that was read by the NLD?
Well, there was a reference to illegal spying programs, and I think the problem as I see it, is that the programs have not been found illegal, and yet they are problematic. That's the source of consternation, that the programs have been embraced by congressional officials and by judicial officials, and yet the challenges they pose, in my view, have not been fully addressed. Mr. Inglis saluted your courage at the beginning. I would like to say I live in Washington, D.C., where even the lowliest of officials is surrounded by a phalanx of staff, and you just can't get to them. And yet, here we have the deputy director of what I think must be the most secret agency in the United States government, giving you as good as he got. And it seems to me that requires a degree of courage also, and so I'd just like to say I think NSA is really well served.
And
Jack, I mean this seriously, if you're looking for a job in another year and a half, think of us. You can influence us from the inside.
And the response to the next speaker, next person I'll call
Thank
on
you.
thank you very much, Jack. Response to the next speaker may require even more courage because Spencer Ackerman from The Guardian is apparently in the audience. And welcome, and please ask your question
Thanks.
the speakers.
Mr. Inglis, do you think it would ever be appropriate for a law enforcement agency like the FBI, the DEA, or any other to query any of NSA's databases directly? I say this because, for the relevance of that question, one of the bills right now before the Senate, Dianne Feinstein's bill, proposes that for law enforcement purposes. Is that ever appropriate? And if I can ask another very quickly, when you mention the authorities that you can bring to bear on collection problems, whether it's 702 or 215, based on the three questions you laid out before, is it ever appropriate, and does NSA ever toggle between not just those, but also Executive Order 12333?
Yeah, so two good questions. On the first question, I would say I'm not familiar with the legislation that you're talking about, but would say that first and foremost, I'm a foreign intelligence organization, and the authorities that I then execute are against the purpose of developing foreign intelligence that might then inform instruments of national, sometimes international power. So the CIA is a customer of mine. The FBI is a customer of mine. But I don't provide domestic intelligence for the FBI. I essentially provide foreign intelligence insights that might then cross the seam and give them a tip as to how to expend their precious domestic resources to prosecute terrorism, counterintelligence, things of that sort. So I can imagine situations where I, on their behalf, am querying my databases, foreign intelligence databases, to inform those instruments of power. I'm not yet in a place where I understand how I might give them direct access to those databases for their authorities. That, I think, would be problematic. But again, not having seen the legislation, I'd have to see that to have a better understanding of it. And your second question again was?
Can you toggle not just between 15
yeah.
and 702, but
So that question, that's a great question. It turns out that that's the reality of my world, which is that these authorities don't stand in isolation. So oftentimes when somebody asks the question of what value did this instrument of your kind of intelligence capability provide in and of itself, all by itself, that's generally not the way it works. The way it might work, so let me give you an example using, say, 702 and 215 together. 702, again, which allows me to, with some knowledge of who it is I'm interested in, based upon the intelligence requirement, applying the right authority, foreign person in a foreign place, but using U.S. infrastructure to collect their communications, might say that this person of interest, say maybe it's a terrorist, is talking about, is fomenting a plot that looks like it has a connection into the United States. That would give me a clue that I maybe should employ the 215 data set, take the seed selector, right, the telephone number, and apply that against 215 to see if then I can discover kind of a connection of that plot into the United States. If I were to find one, I would turn that tip over to the FBI, but I've used those two in combination. The 215 wasn't useful unless it was properly steered by something else. It works in the reverse as well. But again, if there's a U.S. person involved and I'm chasing the content, I need a warrant, and so there's kind of a stop right in the middle of that, such that I can't actually use one to subvert the other. We don't use these to kind of backdoor something I can't do overtly. Is that the question you asked?
So you never say, if I can't do something under 215, perhaps I can do it under 12333? Or 702, if I can't do something under 702, I might be able to do it under 12333?
In practical effect, you get to the same place. So let's say that I want to try to discover some activity that say, terrorists were having in some ungoverned space, right? 702 is not set up for discovery of that sort. 702 says you have to have a very explicit, right, selector that then you kind of query to say, I want the thing that responds to that. So I can't use 702 essentially as a fishing pond, right, a pool where I kind of fish around and say, I just want to see if there's interesting things in here. But 12333 would allow me in the foreign domain to, with some very precise purpose and some precise aiming, to do some manner of discovery. I could say, so I know something about the nature of this organization. This organization seems to be involved in something illicit. I need to assure myself that that 12333 authority is appropriately applied there, foreign person, foreign place, some expectation of a foreign intelligence return, and I might then be able to use 12333 to find something that otherwise 702 didn't let me discover, right? It might be kind of the foreign end of that communication. So in that regard, you have a greater agility with 12333, but it's not that one can beat the other. There are actually provisions built in that say that you can't cheat. So 702, for example, says, recognizing that you will, in getting a conversation or a communication, pick up two ends, right? There's two ends to every communication. You can't use that to reverse target U.S. persons. It's explicitly stated in the law, right? That if what you're really after is person A and you knew that's a U.S. person, you can't say, well, I'm going to target person B because I know that's a foreign person and I, by then extension, get party A. And there are rules built in that then look for that to make sure you haven't actually cheated to do something that one thing didn't allow you to do, but you're now trying to back into it by using another.
Well, we're starting to run over time. I'd like to allow two more questions in, but to keep questions and answers relatively brief. Douglas Hellman, you gonna stand up and ask your question? To say I'm delighted to have another Penn Law student engaged in our discussion.
Hi, thanks very much for coming here today. I really appreciate it. My question is, you spent a little bit of time contextualizing the recent pseudo-scandal, I suppose, in Norway with, you talked about a chart, whether the United States was doing some wiretapping, and then the Norwegian government came back and said, no, that was something that we knew about, we were okay with it, and you talked about that in your speech a little bit. I was wondering if you could contextualize a little bit the controversy concerning wiretapping Angela Merkel's cell phone and how the response of the German government was completely opposite of that. It was total outrage from the German government, and if you can talk about how much of that was blown out of proportion from the news media, how much of that was scoring political points from the German political parties or on the United States part, and if you could rationalize or contextualize something about that.
Rationalize might be a bridge too far. So I would say on the first point, what I think that's an apt example on the Norwegian business. So to be clear, What was alleged in the paper was that the United States was collecting communications, Norwegian communications, that were essentially from Norwegians in Norway. And the Norwegians stood up and said, no, that's not at all the case. What those are communications that the Norwegians collected in places like Afghanistan, Somalia, places where we kind of have coalitions like NATO in harm's way. So it's Norwegian collection of, right, things of interest to coalitions like NATO, and presented to the United States. The chart that I think the paper must have had said Norway, and it wasn't so much the former, it was the latter, right? So the Norwegians came out right away and said, hey, it's not what it is, right? This is something completely different. I can't speak to the Merkel accusations except to say the following. That just remember the trace chain that I gave you, which is that I have to have an intelligence priority that I'm pursuing. Every report I write, right, has to cite, what is it, what intelligence benefit was I essentially trying to achieve here. I have to have an expressed authority that is lawful under United States law, right, under the kind of the scheme that I've described here, and that I think most people would say involves multiple branches of government, and I'm held to account as to whether I've done that. The inherent nature of foreign intelligence is that it, in its most extreme case, exercises sovereign power on behalf of one nation to the potential disadvantage of other nations. Nations are better when they lean towards each other and collaborate, as we have on things like counterterrorism, counterproliferation, activities in places like Iraq and Afghanistan. And I think that our then response to these events should be, is there some then way forward that has us leaning towards each other and trying to figure out what we do in terms of the white list together, as opposed to trying to describe what the blacklist is of those things that nations do out of their own sovereign interest.
Finally, I'd like to invite Sharon Lloyd to give the last question. Sharon is a very well-known political philosopher and who's affiliated faculty with CERL, and she'll ask a question that's a little broader think than some of the details we've been discussing.
Yes, it's philosophy, but don't be frightened. Mr. Inglis insisted that liberty and security are not counterposed values, that we shouldn't think of ourselves as engaged in balancing them, and that, it turns out, was actually the position of the infamous absolutist Thomas Hobbes, who thought that you actually could not trade off these values because the only environment in which you'll actually be able to pursue your own ends, that is, act with liberty, is one in which you have security. But of course, the conclusion he drew from this is that both of these ought to be within the hands of the absolute state. And our question is really, who gets to decide this? So you suggested that, well, there are elements of the judiciary and of the legislative branch as well as the executive. We have the trifecta. Madison would say we have a government. Yes, but we think of ourselves as having a government. We think of ourselves as being self-governing, right? We have a government of, by, and for the people. So now it looks as if we have multiple overlapping sovereignties, and they may well disagree. Now, of course, if it's secret what the shadow trifecta government is doing, if we don't know what that is, we may not know that we disagree. But really my question is one about secrecy. If there's this possibility of multiple overlapping sovereignties, the sovereignty of us, the people, we the people, and the sovereignty of this trifecta, don't we at least need to know what that entity is doing? So don't we at least need to have publicity and disclosure of this information so that we can actually decide this question?
Let me begin by asking Steve Aftergood to respond to this, and then Chris Inglis, the final word.
Well, people literally write books about that sort of stuff. If it's not heresy to say so here, I think Benjamin Franklin's famous quote is kind of wrong. We do in fact trade liberty for security all the time, and I think we do so necessarily. Secrecy is inconsistent with pure democratic government. It reduces the effective scope of popular consent. You can't consent to what you don't know about. but you run the country with the government you have, and you try and make it better as you go along. I think one of the orders of business, one of the top orders of business, is to improve the quality of our secrecy judgments, to narrow and focus them to with precision, so that we have the least amount of secrecy necessary, and then that will provide broader reign for democratic processes to operate, for better or worse.
Chris, do you agree that we should have the least amount of secrecy possible?
And no less. So I don't think we made Hobbes' choice. We do have a representative form of government, and it wasn't made to be efficient. It was made at the end of the day to achieve the kind of internal checks and balances such that we would incrementally, some might say lurch, but incrementally make our improvements across time. And so we have what we intended to have, which is something that has this raucous, sometimes horribly chaotic debate taking place inside, which ultimately gets to a reconciliation. Maybe not in the time that we would prefer, but it's not efficient. But at the end of the day, it's what was intended. And I think to the degree that you say, should we have greater transparency about these things, the question always comes to who's we? Right? If it's 315 million Americans, you necessarily have included then 7 billion citizens of the world, and some of these things are necessarily secret if they're in fact the means by which we hold our adversaries at risk. And I agree that that should be the minimum set possible. But some of those things then require surrogates to stand in the shoes of the American public, the elected officials, the judiciary, the executive branch, to stand in the shoes of them and then to apply all the governance that's intended by our Constitution to achieve a result that the public can and should have confidence in. Those don't always come in the same package. So.
Please join me in thanking our